This Cozy Link story is based on true events. However, names and some details have been altered to preserve the anonymity of those involved.
John, I think our landlord changed the lock.
In the dense urban jungle, where Homo sapiens often coexist in tiny shared territories, conflict is as inevitable as a squirrel stealing birdseed. This is the story of a contentious dispute between two tenants and their landlord. The saga unfolds in the court of reason. The dispute unveiled. In the chilly days of early winter, two friends, John and Sarah, signed a roommate agreement with Mr. Thompson, renting a bedroom and shared spaces in his apartment. Peace reigned for about as long as a snowflake in a toaster. Not long after moving in, they realized it wasn't the right home for them.
I can't stand it here.
Tensions erupted when John and Sarah decided to migrate early in mid-spring, a month before the lease was due to end. The locks are changed. In late spring, a curious event occurred. Without even a carrier pigeon to send word, Mr. Thompson changed the shared entry lock and revoked the tenant's precious Wi-Fi access. This action, claimed to be for the protection of his precious appliances, was seen by John and Sarah as a breach of their sacred rental agreement. They documented this puzzling act, adding a crucial element to their budding case. The Battle of the Claims. Mr. Thompson's claim was ambitious, around $2,000 for unpaid rent, $300 for his valiant housekeeping efforts, and $100 for a 30-year-old stove that met an untimely demise. In a counterattack, the tenants demanded the return of their damage deposit and arguing that Mr. Thompson's actions had rendered them rent-free for the final month. The court had to unravel this tangled web of claims and counterclaims, much like a cat with a ball of yarn. Weighing the evidence. The court, guided by principles of law, fairness, and a dash of common sense, sifted through the evidence and written submissions. The credibility of each party's narrative was crucial. Mr. Thompson's claim of a necessary lock change was weighed against the tenant's right to unrestricted access until the lease's end. The court concluded that Mr. Thompson's actions were as fishy as a cat at a seafood buffet, relieving the tenants of their rent obligation for the final month. Next, the court turned its attention to the damage deposit. Claims about the geriatric stove, the broken entry knob, and other alleged property damage were meticulously evaluated. The absence of a formal walkthrough inspection left gaps wider than a hippo's yawn in Mr. Thompson's claims. Unsurprisingly, the ancient stove was deemed beyond the tenant's responsibility. However, the broken entry knob, likely damaged by the tenant's frustration, warranted a minor deduction. Resolution delivered. In the end, the court ordered Mr. Thompson to return the damage deposit, adjusted for the entry knob costs. Additional claims for housekeeping and damages were dismissed due to insufficient evidence, as flimsy as a spider's web in a hurricane. This court's decision stands as a testament to the delicate balance of justice in the urban wild, resolving disputes swiftly, fairly, and with just a pinch of hilarity.
Was this story toasty enough for you? What would you have done differently if you were the home user or the homeowner? Subscribe and come visit us at cozylinks.net for more.